So, you're an investigator. You've just filed your final report. Feels like the finish line, right? Well, I hate to break it to you, but it's not. That report? That's actually the starting gun for the real battle. Today, we're going to build a field guide for what comes next, surviving the moment you have to defend your work, under oath and under fire.
So let me ask you this. When an investigation ends, what's the final step? I bet a lot of you are thinking, filing the report, of course. And hey, you're not alone. That moment totally feels like a victory. But here's the thing. It's a really dangerous misconception.
Because the real final step, it's defending that report. And get this, it doesn't just happen in one place. We're talking about 4 very different, very high-stakes rooms. Each one has its own rules, its own dangers, and its own unique strategy for survival. This is where your work really gets tested by fire.
All right, let's dive into our first challenge, the deposition. And right off the bat, I want you to forget everything you think you know about legal stuff. This isn't really about justice. It's a mind game. It's a pure endurance test, and it's designed to find your breaking point long before you ever set foot in a courtroom.
So, what exactly is a deposition? Well, officially, it's a pre-trial, under-oath questioning session. You're probably in some bland, generic conference room. And for the opposing attorneys, the goal is simple: discovery. They want to find out every single thing you know, and, this is the important part, they are hunting for weaknesses. Weaknesses in your testimony, weaknesses in your credibility, anything they can use.
Now, the vibe in here can be super deceptive. It feels kind of informal, you know? There's no judge, no jury, it's just you, the lawyers, and a court reporter. But do not be fooled by that. There's a reason they call this a fishing expedition. The lawyers can ask pretty much anything they want, and they're just hoping you'll get comfortable and volunteer information that you absolutely shouldn't.
So how do you survive this thing? Okay, listen up, because this is the #1 rule, and it's simple but powerful. Answer the question honestly, concisely, and then you stop talking. Seriously. Attorneys are absolute masters of using uncomfortable silence. They'll just stare at you, and they're waiting for you to get nervous and just start talking to fill that quiet. Don't you dare fall for it. It is a trap every single time.
All right, so once you've survived the psychological warfare of the deposition, we enter a completely different world. Next up is the grand jury. And here, your role does a complete 180. You go from being a defensive witness to being the star of a solo performance.
So, the grand jury, it's a pretty unique part of the American criminal justice system. Basically, it's a secret proceeding. A prosecutor presents all the evidence to a group of jurors, and their job isn't to decide guilt or innocence. Nope. Their only job is to decide if there's enough evidence, probable cause, to formally charge a suspect. That's it.
But here's what's really interesting. Think about who is not in that room. There's no defense attorney. There's no judge. It's literally just you, the prosecutor, and the grand jurors. And that one-sided setup, it changes the entire dynamic. There is nobody there to object, nobody there to challenge a single thing you say.
And because of that, your role completely transforms. You become the teacher. You're what they call the summary witness, and your job is to walk the jurors through the entire case, from start to finish. You have to present a clear, compelling story that makes all the pieces of evidence fit together. In this room, clarity is your greatest weapon.
Okay, now for the one we all know from the movies and TV shows, the trial. This is the main event, folks. It's the most formal, the most high-stakes arena of them all. And if you're an investigator on the stand, get ready, because it's a battle fought on 2 very, very different fronts. First things first, you've got to know what kind of trial you're in. Is it a civil trial that's between 2 parties, like a lawsuit? The standard of proof there is lower, what they call preponderance of the evidence. Just think of it as tipping the scales, like 51% certainty is enough. But then you have a criminal trial, that's the state versus a defendant. And the standard there? It's the highest in all of law, beyond a reasonable doubt. And trust me, that distinction changes absolutely everything.
So here's that 2-front war I was talking about. First, you've got direct examination. That's when your side's lawyer is asking you questions. They're usually open-ended, you know? What happened next? Their goal is to let you tell your story. But then comes cross-examination. The opposing lawyer steps up and they're hitting you with these sharp, leading yes or no questions. You didn't see that, did you? Their only job is to poke holes, create doubt, and challenge every single fact you've presented. You have to pivot, instantly, from being a storyteller to being a laser-focused defender of the fact.
Okay, so we've covered the big, formal legal arenas, but our last challenge, well, this one's a bit of a curveball. I like to call it the Wild West of testimony, the administrative hearing. This is the place where all those strict rules of the courtroom, yeah, they pretty much go right out the window.
So what are these? Well, they're kind of quasi-judicial. Think of things like employment disputes, union grievances, maybe a hearing about a professional license. And instead of a judge, you've often got an arbitrator running the show. The focus here isn't always strictly on the law. A lot of the time, it's all about internal company policies and procedures.
Now, the atmosphere can feel a lot more relaxed in a trial, but that's what makes it the Wild West. The rules of evidence are way looser. For instance, hearsay, secondhand information, he said, she said stuff, that's often totally allowed. Something that would get thrown out of a courtroom in a second. And that can catch a really good investigator completely off guard if they're not ready for it.
So your whole strategy has to adapt. The fight in this room isn't always about what's technically legal. It's about what's fair, according to the organization's own rulebook. So the winning move? You have to constantly, relentlessly tie your investigation back to specific policy violations. You're not just presenting facts. You're saying, I investigated a violation of Policy 7.2, and here is the specific evidence that proves that specific violation.
So after touring these 4 really challenging rooms, what's the big takeaway here? It's this. There is no one-size-fits-all strategy for testifying. It just doesn't exist. The master key, the thing that will help you survive and even win, is knowing the specific rules of the venue you're in and being able to adapt your game plan on the fly.
Let's just break it down one last time, real simple. In a deposition, the biggest risk is you talking too much. In a grand jury, it's being unclear or confusing. In a trial, it's getting ripped apart and impeached on cross-examination. And in that administrative hearing, the danger is being seen as unfair. See? 4 rooms, 4 completely different dangers, and 4 totally different strategies you need to survive.
Okay, so we've walked through the whole gauntlet. The mind game of the deposition, the solo performance of the grand jury, the main event that is the trial, and the Wild West of the administrative hearing. So the question I'm going to leave you with is this. Now that you know the rules of engagement for each one, which of these rooms would you least want to find yourself in? Really think about it.